Hello and welcome to our third video in our series on Section 504 of the Rehabilitation Act of 1973. Once again, I am Sharon Ackah, Chief of the EFM Legal Assistance and Policy Branch. In the last few videos, we talked about Section 504 requirements related to the provision of accommodations to students with disabilities. Now, let us talk about what happens when conflicts arise in between school districts and families when dealing with these accommodations. By law, schools must conduct an impartial due process hearing when parents disagree with their findings regarding an accommodation. In fact, impartial hearings are necessary whenever there is a disagreement between parents and schools regarding identification, evaluation, or placement, in addition to the accommodations. Here are some things to know about impartial hearings under Section 504. When there is a need for a hearing officer can be appointed by the lead education agency, or that function can be contracted out to an outside entity. Parents are required to be given an opportunity to participate and be represented by legal counsel, but the details of the process are at the discretion of the lead education agency. But ideally, any concerns that you have about your child's needed accommodations can be addressed at a 504 meeting, and there would be no need for a hearing. Here are my tips for having a successful meeting about your child's needed accommodations. Review existing plans before the meeting. Evaluate the success of the current accommodations. You might want to speak with your child's teacher. Think about how have these things been working thus far, and what would you like to see changed? Think about those potential accommodations. Write them down. Make a list for yourself so that you are prepared when you enter into the meeting. Help the team to get to know your child, to help tailor the team to the student, i.e., if there are additional persons that you find might be beneficial in the meeting to assist in understanding the accommodations, why they're needed, and what's needed, let the team know that and understand why your child has those requirements and would benefit from the additional participants within the meeting. Ask for clarification of terms, accommodations, and ask for copies of the meeting notes at the end of the meeting. Ask the team to detail and be very specific about the accommodations. For example, if there's going to be an accommodation about preferential seating, we'd want that 504 team to identify where your child will sit in the classroom, not just simply that there will be preferential seating. Get a copy of the 504 plan in writing. But know that the law does not actually require that the plan be in writing. This is something that you will request from your 504 team. There is no specific requirement for guardians to be invited to the 504 meeting, but most schools do understand that you have a valuable input for the 504 team and generally would extend that invitation. If it is not voluntarily extended, I recommend that you request to be a part of the team. As a reminder, your local legal assistance office is standing by to assist you further, to understand your rights under 504 and to navigate your special education concerns. I look forward to bringing you more information for your advocacy toolkit in our next video.